the evidence is on the face of the pink sheet. I have a pink sheet from you as EC, and from EC, the figures on the pink sheet that you've given to me shows that I've won in 31 polling stations. And if this 31 polling stations is added to the 110, it puts me ahead, and I beat my opponent to 2,352. You know, a gap of 2,352. However, during the collation, you find out that the figures that is coming from the collation are different. So this is what we pointed out, you know, and it's surprising the stance they're taking, because my opponent's agents were in the room at the time and they had agreed. In fact, the suggestion, from what I understand, came from them. I didn't initially agree that the 31 police stations be set aside, because I knew that this was my numbers. I was going to be disadvantaged, you know. So I mean, it wasn't a case. We still stand that, I mean, if the 31 police stations with the pink sheet that we have given to us by the EC is anything to go by, we would have won the election. We'd won the election, in fact, you know. And if it comes to KWESI Central, for instance, there are some police stations that the NDC has never ever won in these police stations. This time around in 2024, we won a number of these polling stations. Interestingly, whilst everybody is there, pink sheet shows that you've won. You come to collation and the figures have been swapped. You know, and so that's the point that we made during the collation. That before the EC themselves, they have their own policies. We are not the ones that decide for the EC what to do regarding declaration. They went in and they did their declaration. As it stands now, that duty of declaration, I think, to be fair, has been done.
That's why you said that it was done at duress.
Of course, I mean, it was never done under duress. I mean, it will require a whole court petition to be able to determine some of these issues that they brought to. But be satisfied, some of you were in court, you heard them. The narrative of duress was largely missing. You know, in our case, for instance, I mean, when my opponent had written to the EC, the letter that was read in court, for instance, he was reiterating to them or affirming that the declaration had been done. He only wanted it to be revoked because of irregularity and coercion. These are two different ways. I mean, if you break it down. So yeah.
Okay, so that is Baba Sadiq, one of the parliamentary candidates whose constituency is affected by this court action, and his lawyers made a submission in court, made a very interesting submission to have in his favor, just so to ensure that they have a decision in their favor. So you could see a lot more people in court monitoring proceeding. Party faithful have all come to the court, and you see a lot of people gather here, and all of the people have also come to. So as you can see a lot of singing from some section, the cross section of the NPP. So we just get closer to Dr. Justice Shemsai, who has also been in court right from day one. He seated, monitored whatever was happening, and he gave us some perspective as to what exactly has happened. Now, you were in court, you heard argument being made in respect of each of the constituency. First of all, with Sama Central, you heard the argument that were made. Submissions were made, videos were played in open court. From where you stand, what does it mean to the case before the court, really?
So the Tema Central issue is one of whether or not there was a declaration. I think that was the main thing. And you will see, I think on the 13th, the EC issued a press, statement concerning the collation that was happening at the police, police training school. And the EC itself called it a recollation. And in that, you see that the video played showed that there was a declaration of the result. Now, the petition or the applicant's concern was that the declaration was not proper. But that obviously is not a question for mandamus to be. It requires a certiorari. If you allege that something was done improperly, you apply for it to be quashed, not to ignore it and then issue an order for a different thing to be done. That was the fundamental flaw in that particular case. But the other issues are that for mandamus to be, granted, you need to show some things. One of them is that you have made, there's a statutory duty which is expressly stated in law. There must be a demand that it should be performed, and there must be a refusal that the demand will not be performed. Clearly, there is no evidence that there is a statutory duty called recollation. Once collation is done, the next thing you do is to challenge it by way of what? Election petition. But there's nothing like recollation. That has been our argument. Secondly, there's no evidence. What we saw was that a letter purported to have been submitted to the EC.
So in respect of those letters, what exactly are the letters supposed to confirm before an action of this nature is initiated?
Yes, so those letters are supposed to first indicate that there is a statutory duty, and secondly, that they are demanding that the duty be performed. And the EC should have responded or replied to the letters to say that I will not perform it. Then the action, the course of action for mandamus would come to exist. In this case, there's no letter from the EC indicating that they are refusing to perform those functions. And indeed, if you look at the posture of the EC during the proceeding, you could see the readiness to perform the duty. So then the question we ask is, why come for mandamus if all you want is for the EC to perform a duty, which they are willing to perform anyway? What is holding the EC? But that is why they are not telling the court the whole truth. They are proceeding on the assumption or the falsehood that there were no collation, and that was the argument of the applicant. They were saying that there was no collation, but of course, thankfully, because of technology and video, we have all seen those collations being done. We have all seen the declaration being done. Their problem is that the declaration was not proper, it was not in compliance with law, and our position is that if that is your concern, then what you need to do is not to ask for mandamus, is to ask for certiorari right to question, and that can be done through an election petition. So you have no room, but the judge disagreed with us and ruled the other way.
Yeah.
And that,
so if you look at the objection that was raised, one of the points that you indicated was that this very mandamus application was defective in nature and it was incompetent based on grounds that you felt that a declaration have been made, and so if there's anything, you come by an election petition. The court disagrees with you. The issue about threat and duress and coercion, how does it play in this whole matter?
no, we think that those are serious allegations. Threats, use of force, fraud, those are significant allegations. And even in normal civil rate trial, if you allege such things, you are required to particularize them, and they are supposed to be tried. You call witnesses, they will be cross-examined, counter evidence will be provided. You cannot do that in this particular process of mandamus. So that has been our concern, that it's as if the case has been converted to an election petition. You could see that when you read even the documentation that were provided, it is clear that you cannot make any concrete decision on them unless you hold a trial, and that trial cannot happen. And of course, it did not happen today because the judge is going to give a ruling on Saturday. So we believe that if the rules the rules regulating mandamus and all the legal principles that we have stated, if those rules are followed, we expect that Saturday will be a favorable outcome for us. And if it is so, then democracy and the rule of law will prevail, because we do not believe that the EC has the capacity to determine matters of legality. And by the fact that they are alleging it and we are denying, means that there must be a forum, a third forum for that to be decided, and cannot be decided by the EC itself. So that is why the framers of our laws, the constitution and the constitutional instrument, were specific that if you have any issue with any election result, you need to what? File a petition. And there's a good reason for that.
So there are those who are wondering what exactly will be happening, or the fate of these parliamentary candidates will be after Saturday, when we know the outcome of whatever will happen. But with this mandamus application, the court fixing Saturday to determine this mandamus application, what should the parliamentary candidate be thinking, and their constituent, what should they be thinking?
I think they, as far as our candidates are concerned, they are not happy with the situation because they have been duly declared, and they should be treated as all parliamentary candidates have been treated. You wait and then you challenge but they are being treated, taken through a process which is needless. Now, on Saturday, the worst case scenario for us is that the court will order a collation or a recollation for that matter. That will still not be able to inure to their benefit directly, because we believe that we have enough, but just that we want the rule of law to prevail. In principle, this process should not have been going through. They shouldn't be taken through this process at all. And I think it should have ended this morning with a ruling, but unfortunately we have to go through and extend their sleepless night has to be extended for another few days. But we are hopeful that eventually rule of law will prevail and the outcome will be favorable, one that will help not just our PCs, but also the country as a whole.
Thank you so much, Doc. So that is Dr. Justice Shremsai. Rabna Obin is also here. He's actually been sitting throughout the court session, and then he has been very forward looking, especially about whatever processes were going to happen or the outcome.